I want to talk today about what to do if you're in the unfortunate situation of being sacked from your employment. Obviously, if that happens to you, it's a very traumatic situation. You were not expecting it. Usually, it means that you suffer a loss of income. It means that you suffer a loss of friendship with work colleagues, perhaps, and it just generally can throw your life into disarray. Notwithstanding that trauma, it's very important that you get advice from a lawyer very quickly, because if you are to seek any remedy as a result of a dismissal that is unfair, you must lodge an application either in the Fair Work Commission or in the State Tribunal, depending on the circumstances, within 21 days of that dismissal occurring. When you contact a lawyer, he or she will ask you a number of initial questions, because there are a number of barriers to whether you can make an application for unfair dismissal, and you must cross those hurdles before the application will be accepted as a valid application. So when we initially talk to someone on the phone or face-to-face, those questions will include, first of all, the name of the employer, and that will indicate whether the application should be made in the state or federal jurisdiction. If the employer is the South Australian Government or South Australian Local Council, then the application will need to be filed in the State Tribunal. Otherwise, it will need to be filed with the Federal Fair Work Commission. So, first of all, the name of the employer, and then furthermore, we need to know exactly when the dismissal will take effect. So you might receive notice, for instance, saying that we're terminating your employment, we're giving you 4 weeks' notice, so the dismissal will take effect in 4 weeks' time. So the 21-day time limit will take place not from when you get that letter necessarily, but from when your actual employment finishes. Then we will ask you whether your employer, how many employees there are at the work site. If there are less than 15 employees, then there are different criteria to be considered, and in particular there's a small business code that will need to be considered to find out whether your dismissal was harsh, unjust or unreasonable. And that terminology, harsh, unjust or unreasonable, is the key criteria for deciding whether you may have a remedy or not. Then we will ask you when you commenced your employment, because if you commenced your employment less than 6 months before the dismissal, then you won't be able to make an application for unfair dismissal, but there may be other remedies available to you. If your employer is a small business that is less than 15 employees, then you must have been employed for 12 months before you can make an unfair dismissal application. Now, of course, there are other possible remedies as well. I'm primarily in this video talking about unfair dismissal applications, but there may also be remedies under the relevant discrimination legislation or under the workers' compensation legislation. And those remedies may not be mutually exclusive. That is, you may be able to take a workers' compensation claim as well as an unfair dismissal application. You will need further advice about that as to whether your circumstances fit the relevant statutory criteria. A further issue that the lawyer who's meeting you or talking to you will need to consider is what is your salary. Your salary must be less than a certain salary cap. Presently, that salary cap is approximately $148,000. So you must be earning less per annum under that cap before you can make an unfair dismissal application in the Federal Fair Work Commission, unless your salary is paid under an award or an enterprise agreement. If that is the case, then you will need to tell the lawyer what the name of that award or enterprise agreement is, and the salary cap will not apply to your situation. The next issue the lawyer will then ask you about is the reason for dismissal. There may be there may be a range of reasons for termination of employment. One is redundancy. If your employment was terminated because you were made redundant, and that was a genuine redundancy, then you won't have an unfair dismissal remedy. Now, there are certain criteria as to whether a redundancy is genuine or not, and it will also depend upon the particular circumstances, and again, a lawyer can advise you further about that. Other reasons for termination may be that you were on a fixed term contract and the term of that contract has expired. Again, if that is the case, then you may not be able to make an unfair dismissal application or obtain a remedy. A common reason for dismissal is poor performance. Now, if your employer has dismissed you because supposedly your performance has not been up to scratch, the employer must have first of all followed a range of procedures before they can get to the dismissal stage. The employer should have warned you that you were not performing to the standard required. The employer should have met with you and counselled you about that and had a discussion with you about what you need to do to lift your performance to the standard required. That could include offering you further resources to enable you to perform your job properly. But unless you've had the opportunity to have improved your performance over a period of time, let's say even a couple of months, then the dismissal is likely to be found to be harsh, unjust or unreasonable. Another common reason for dismissal is misconduct. Now, again, the situation can vary widely there, but if it's misconduct that is not extreme, one would normally expect that in the first instance you would have been given a warning about a certain type of behaviour, and again given the chance to not commit that offence again before your dismissal. In certain circumstances, however, if the misconduct is considered to be serious and willful misconduct, then an employer can terminate your employment without notice. The lawyer who meets with you will go through all the circumstances of the termination, and to assist the lawyer, it's very useful if you could provide them with just a succinct chronology of the events that have led up to the termination of employment. And obviously the first date on that chronology would be the date you commenced, and then the next date might be the date in which certain things started to happen, and that may be, for instance, that a date in which someone first remarked about your performance not being to the level required, or certain behaviour occurred in which you were told off about that behaviour. So it's important to, on the left-hand side, have all the relevant dates, and on the right-hand side have all the events or issues that eventually led up to the termination of employment, so that the lawyer advising you can look at that as a snapshot and say, well, yes, I think actually you've got a reasonable case here, or no, I don't think you have. A lawyer advising you will look not only at the actual reasons for the termination, but whether the employer followed fair procedure in making that dismissal. There is another remedy available to you if you come under the Fair Work Commission jurisdiction. That's the federal jurisdiction, and that is what's called an adverse action complaint. And that may arise in certain circumstances. For instance, if you've been discriminated against, and that discrimination has been a cause of your dismissal. You may, for instance, have been terminated because you were ill, but employer can only terminate your employment if you have exhausted your sick leave and then had a further period after that in which you've taken unpaid leave and you've still not been able to get back to work. So if an employer has terminated your employment on the grounds of ill health, then there could possibly be an action for adverse action, which is a separate action to that of unfair dismissal. But in both of those actions, again, if it relates to a dismissal, then you must lodge the application within 21 days, and that is a very strict time limit. The Commission will generally not grant you an extension of time to lodge an application. The lawyer who you meet will then discuss with you what you're actually seeking if you take an application for unfair dismissal. The primary remedy is reinstatement, and obviously getting your job back is the most valuable thing for you. The Commission, however, will look carefully at whether reinstatement is viable in the circumstances. So the Fair Work Commission is less likely to grant reinstatement if it's a small business employer and your relationship with the employer has broken down. The Commission will examine all the circumstances and may consider, well, it's not likely that you're going to be able to get back to a good working relationship or even a normal working relationship in a small business given the events that have occurred. If, on the other hand, you're employed by a large corporation, then even if there's been a souring of the employment relationship, the Commission is more likely to find, well, the employer has human resources section available to it. There could even be mediation between the parties. You could even be moved to a different section, and you have more chance of being re-employed and obtaining an order from the Fair Work Commission that you be reinstated in that situation. On the other hand, if you're not reinstated, then the Commission may order compensation if they found that the dismissal was harsh, unjust or unreasonable. The compensation for an unfair dismissal application, however, is not great. The maximum is generally about 6 months' pay, and that would often be only worthwhile if your pay was at a reasonably high level. having regard to the legal fees which may be involved if the matter proceeds to a full hearing. You may unfortunately find that your legal fees are just about what you might get by way of compensation. And that's why I'd say reinstatement is the primary remedy. If you're going for reinstatement, you want to be reinstated, and there's a reasonable prospect of being reinstated, then it's far more valuable outcome for you than simply being awarded compensation. The other type of application, however, that I mentioned before is an adverse action complaint. There's no cap on the compensation you might receive there. So if the reason for your dismissal was because you had been discriminated against, or you've been dismissed because of ill health, or because you had made a genuine inquiry or complaint about your terms of employment, and the employer turned around and said to you, well, if you're making a complaint about your wages, I'm just going to sack you, for instance, then that may constitute an adverse action complaint. And even if you don't want reinstatement with that employer, you could be subject to substantial award of compensation. So that is definitely worth looking at in particular circumstances. You can either take an adverse action complaint or an unfair dismissal complaint, but you can't take both at the same time. It's very important that you make contact with a lawyer or union advisor if you have been sacked, and that you do it straight away. Remember again, you only have 21 days to make an application, but a lawyer will need time to prepare that application. So the sooner you get to see a lawyer or legal advisor, then the sooner that person advising you can obtain all the relevant details and get the application into the Commission. The first stage in dealing with any application will be a conciliation conference, and most matters settle at the conclusion of that conference. Generally, they would settle upon payment of some form of compensation, and in return, the applicant worker would sign a deed saying this finalises all their employment claims against the employer. So, for instance, there will be a conciliation conference. A commissioner from the Fair Work Commission will attend, usually by telephone, at that conference. You'll be in a room with your lawyer. The employer will be somewhere else with their legal advisor, and the parties will put their best case forward. You will say why the dismissal was harsh, unjust, or unreasonable. The employer will say why they consider it wasn't, and then there will be some toing and froing between the parties, usually through the commissioner, and ultimately, in most cases, a settlement will be reached. However, if there is no settlement reached at conciliation, then the matter will proceed before a full hearing. At that full hearing, you will need to give evidence before another commissioner, and you may need witnesses as well to support your case, and the employer will also need to attend and provide witnesses. As I said earlier, that can be very costly, and generally I would only recommend proceeding on that path if you genuinely want reinstatement and have a good case to obtain reinstatement, or in the alternative, if you've got a reasonably high salary, so the compensation would be worth the legal fees you pay for that. So, in conclusion, good luck. If you are dismissed, get advice and proceed on that advice, but do it as a matter of urgency. But hopefully that will never happen to you. Thank you.